Many foreign investors enter Vietnam believing that once they own shares in a company, they are in control. On paper, this assumption seems logical. Ownership should mean authority. But under Vietnam company law, control is not determined by how much you invest. It is determined by how your legal documents are structured. And this is where many investors make a critical mistake. The most important document that defines control in a foreign-owned company in Vietnam is the company charter. A company charter in Vietnam is not just a formality required for registration. It is a mandatory legal document under Vietnam company charter requirements. It governs how decisions are made, who has authority, and how corporate governance functions in practice. Many foreign investors focus on investment registration, licensing, and market entry strategy. The company charter is often treated as a standard document, sometimes copied from templates or prepared by local partners. This approach creates risk. Without proper legal review, the charter may not reflect the investor's intended control structure. Instead, it may unintentionally limit their authority. In Vietnam, control is defined by specific clauses in the company charter. These include voting thresholds, board composition, and decision-making authority. A foreign investor may hold a majority of shares but still lack control if these clauses are not properly structured. The difference between control and lack of control can depend on a single provision. One of the most critical elements in a company charter in Vietnam is the legal representative. This individual has the authority to act on behalf of the company in transactions and legal matters. If the charter does not clearly define or limit this authority, the legal representative may act beyond the investor's expectations. This is a common source of disputes involving foreign investors in Vietnam. Some investors rely on shareholders' agreements or internal arrangements to secure their rights. However, if these agreements conflict with the company charter, enforcement becomes uncertain. Under Vietnam business law, authorities and third parties often rely on the charter as the primary document. This means that protections written elsewhere may not be effective if they are not reflected in the charter. There have been real cases where foreign investors in Vietnam lost operational control of their companies despite holding majority ownership. In some situations, they were unable to access bank accounts or replace management. These outcomes were not caused by illegal actions, but by gaps in the company charter. This is one of the most common legal risks when setting up a company in Vietnam. Using a standard template for a company charter in Vietnam may seem efficient, but it often fails to address the specific needs of foreign investors. Templates do not account for unique ownership structures, governance requirements, or risk allocation. As a result, they may create a legal framework that does not align with the investor's objectives. A properly drafted company charter in Vietnam should clearly define ownership rights, governance structure, and decision-making processes. It should align with Vietnam company charter requirements while reflecting the investor's actual intentions. It should also anticipate potential conflicts and include mechanisms to resolve them. Most importantly, it should ensure that control is not left to assumption. At LTS Law, we provide legal services for foreign investors in Vietnam by drafting and reviewing company charters that are both compliant and strategically structured. We ensure that your charter reflects your investment objectives and protects your control in practice. Before setting up a company in Vietnam, visit lts.com.vn and consult with our legal team to ensure your investment is built on a strong legal foundation.